Now it's time. We will have our post-lunch panel discussion session, which will be our last panel discussion on the topic regulatory guardrails while conducting investigations. Before we embark upon the most awaited and exciting moment of this conference with the distribution of the Lex Falcon Global Awards. For this, I would like to call upon stage Mr. Nitin Bhuwania, SVP Legal and Compliances, Easebuzz. Please have a huge round of applause, everyone, for Mr. Nitin. Ms. Sushma Shankar, Senior Legal Counsel at Accenture Solutions Private Limited. Please have a huge round of applause for Ms. Sushma Shankar, everyone. Moving forward, I would like to call upon stage Mr. Vicky Gala, who is an Associate Managing Director in Forensic Investigation and Intelligence Practice of Krol, a global risk consulting firm. He has led 100+ complex investigations during his work span of 18 years, and a few of such matters have those been extensively been covered in the press. He will lead this session today and touch upon various regulatory guardrails that he has experienced while conducting such investigation. Please have a huge round of applause, everyone, for Mr. Vicky Gala.
Hello. A nice time of the event when we've just done with lunch and we have to keep a charming face to present the audience on something which is more interesting. Thanks for, first of all, giving us this opportunity to speak on the dais. In my career of investigation that I've been doing since 18+ years, what I've always been told as a buzzword is, please keep it confidential. And on the other hand, my clients and us as consulting firms have to adhere to a lot of regulatory inquiries. We need to adhere to a lot of regulatory compliances. And hence, it becomes like a paradox where you try to maintain confidentiality, and on the other hand, you need to do disclosures. So, that's the context that we want to just get this and understand this better. Thanks for the panelists. My stalwarts are legal professionals, so although I am a chartered accountant, I'll try to be more talking about the legal side of it. Let me just break down this session more with, I'm saying, just an open discussion with, not need to be a moderator driven, but more to be more conversational. And the first one to start with is, do we only do investigations? No. The investigative mindset is also when you are actually into a transaction. What we term as investigative DD. Even in those, there are so many points which needs to be kept in mind from a regulatory standpoint. Whether you've got right approval from CCI, whether you've got an approval from the SEBI, whether you've got approval from multiple regulatory bodies. So I think the first question which is there is for Sushma. You've been for a while working with Accenture. In your experience on a specific transaction, how do you see you've been able to achieve the requirements of various regulatory bodies?
So see, not many people know about investigations, especially corporate investigation within due diligence. All of us must have heard about due diligence, right? So there are various kinds of due diligence. You have the financial due diligence, the legal due diligence, and then the operational due diligence, right? So when it comes to the financial due diligence, what do? We look into the financial stability of the company, the financial health of the company. And then when it comes to legal due diligence, what is it that we do? We kind of, do an assessment or evaluate whether the target company has complied with certain applicable laws and regulations. One, how is it doing at the organization level in terms of operations? Although it is one aspect of operational due diligence, about employment, the kind of contracts we enter into with the clients, the kind of leases we enter into. So there are various aspects of, the evaluation which we look into when it comes to legal due diligence, right? Having said that, What is investigation in due diligence? That's the biggest thing, right? So when do we actually get into investigation? Investigation is a deep dive of, due diligence. You get into a systematic, evaluation. So in due diligence, at the most, we may ask the target companies to share the documents to evidence the fact that they've been complying with certain things, right? We don't get into deep. So what do we do in investigation? Say, for example, if I have to take a labor law compliance, while setting up a company or an entity, when we're establishing an entity, we have to have an SND registration, shops and establishment registration in place, right? So, during the due diligence, we've been shown that the company has done the compliance. Now what happens is, there's a lot other compliances which follows with this, in terms of maintaining registers, in terms of displaying certain things. Now, how do you know that this is being done, and then that you do not foresee any regulatory action upon this, target company for non-compliance? So you get to know only when you start investigating. So there is an investigative agency, I don't know how many of you know about it, who are, deeply involved in mergers and acquisitions, who kind of, do this. So they get into the investigating part of it.
Absolutely. That's for our bread and butter. Yeah, but Nitin, it will be good to, if you can add an example to it in your career, you've been through any of such matter, and how have you taken it forward?
Thanks, Vicky. And I'm also chartered accountant, so I was fortunate to be a lawyer by heart and by passion. So one of the biggest example which I was part of, and I was fortunate enough to be part of that M&A, which was an acquisition of Dewan Housing Finance by Piramal Group. So I was part of the core team, core people who were handling that diligence. And Sushma rightly pointed out, financial diligence is something which one can understand from the audited balance sheets and the data which is available in the public forum, or whether there is some manipulation done in the balance sheet. But when it comes to legal due diligence, it's a totally different ball game. And why do I say that? Is the diligence report has to give that thought process, that view, that there are things which are legally compliant, the checks in the box are tick, but there are things which have been missed. And what is the impact of that being messed up? So in my experience, and we're talking about experience part here, I was doing the DHFL due diligence, and we had again a large investigative agencies, the Big Fours and specialized firms who were doing that investigation. The main question was like, we can see a lot of circular transactions. Are those circular transactions backed by any documentation? Can we understand what is the layering done on those transactions? Is there you have to get deeper into that, and it's become difficult when you are actually doing a diligence of an entity in such space, which is into a different problem. So it becomes very difficult, and checking out whether the agreements are in place. The employees who are there in the org will always say that all of them is there. What is there is not you are not able to say. You ask for a sample check out of it. Those two is only not available. Again, you get deeper into it. So it's a very interesting area, and M&A, especially diligence, is the most important thing in M&A, because actually the person who is putting in the money or who is getting absorbed, the cultural part and all of that. But when it comes to legal, it's like larger snakes. In financials, you may be like, I'm paying something, but is it worth of that much what I'm paying for it? The legal diligence bring out all of that. A very, very basic example Sushma gave, that whether shops and establishment certificates are there. For a large organization like DHFL, every branch need to have that. So, and when we did the acquisition, every branch certificates need to be changed. So even this is a part of the due diligence, that what all actions you need to take after acquisition of the company. All those signboards need to be replaced. The local regulations related to local laws need to be followed. So it's an interesting assignment which I was part of, and one of the largest deal which went under the IBC, though we had the court approval and all of that, which was there. But again, the DD plays a very important role.
Excellent. So this is good, when you hear about transaction. Now, I think more than half of the time that we spend for our clients has been more towards investigations. And that half of the time that we spend on investigations have a lot of branches to it, but primarily it would be employee misconduct. It could be more related to, maybe a harassment issue, so on and so forth. So, again, Sushma, I want to understand from you whether, what do you mean and what are the type of issues that you have seen, especially when it comes to investigations in your career. And, it'll be good to know about how did you dwell with it then.
Yeah, so I just want to call out, I would be giving certain instances. So this is not with the current company which I am with, but I've seen it in the past and
Absolutely.
basis my experience. So when we talk about investigation or corporate investigation, first thing which comes to our mind is employee misconduct, right? Corporate investigation, misconduct. Misconduct is one, harassment is one, discrimination is one. Now, having said this, there are certain other dynamics, which goes into this, which when we sit at a company, we kind of experience these kind of, issues or concerns, you may say. Now, you have I've seen this instance, like in the past, where two employees were walking together, entering the facility, and they've had a disagreement, right? So this one employee pushes the other, right? So there's an injury caused to another employee, and then in such cases, right, what does the company need to do? Immediate termination, or you investigate, right? So there's an investigation which goes into, followed by a notice or whatever it is. And then I've seen an instance where employee running away with the asset of the company, where he was being discussed about his performance. People are talking about his feedback. You have him, the supervisor, and the HR, and then the employee suddenly, nobody has a clue or an idea that this employee is going to run away now. So, he runs away with the asset, not even the asset of the company, it's the asset of the client. And then goes ahead and files a police complaint saying that, the company harassed me. So there's a different tangent altogether into it. And there again, you cannot investigate this because some third party has already been involved into this investigation, although you are conducting some amount of internal investigation. So these are the scenarios which we see, when we are working in large-scale companies. So if I may ask you, out of your experiences, what are the compliance, requirements which you need to do, especially, like I said, when you see certain acts, do you do an immediate act of termination, or, you get into an investigation? How depth is your investigation, and what is the outcome of the investigation, right?
Excellent. So, I think it very suits the topic of a regulatory guardrail. You mentioned about an FIR, you mentioned about connecting it with a law enforcement agency. Maybe the individual has, although would be a privy to a specific information, would have done wrong in the eyes of the organization, but still he has taken up the safeguard of reaching out to the law enforcement authority. So I know it's a very classic case. I think it's a very good one to know. It's primarily where, number one, in such matters you may need to show the independence. The parties who are involved in that specific matter should generally not be, or should definitely not be, a part of the investigation. Regardless of whether things have gone wrong or right, the first thing that any organization should keep in mind is the independence factor, which can be done by an external third party, or which could be done by an absolutely within the organization by someone who is not a part of that entire transaction. Second thing is, termination, in my view, should not be the direct recourse, because termination primarily gives again open ideas for the other person to go to the other forums and courts and ask for a injunction, ask for a claim. It's important that there is a mechanism in terms of the disciplinary action that needs to be taken by an organization. Parallelly, an investigation needs to be done, and don't be surprised that there would be multiple such regulatory bodies who you may need to reach out to and inform about what has happened, and get that complete investigation done, and then it's a true and fair report. It's basically telling fact finding about what happened, and then based on that, disciplinary action has been taken. So I think that's
that's absolutely right, Vicky. Just to add, we as a GCs have to also ensure that POS Act is there. If there is a harassment case, return need to be filed, annual return need to be filed. The IC committee has to come, and in the return you have to mention how many complaints have been received. Investigation plays important part because the Act talks about doing an investigation by the IC in a certain manner, and all of that need to be recorded, documented, and the complainant need to get all types of protection and support. So termination is no way a answer for an harassment or investigation when it comes to organization. And probably the regulatory guardrails, there are regulation, there are law. We need to do a lot of filings with MCAs also for different aspect. I think recently there is another filing required for MSME, who all are MSME vendors. So even these part becomes very important for considering what are the regulatory guardrails, and being non-compliant or filing a data which is not correct, not right, itself become lot of issues when we're not talking about due diligence, M&A, acquisition. I don't think anyone will be ready to put up money or acquire something which has such issues or such challenges.
Especially, sorry, on this, corporate investigations, the ICC thing, there's another compliance which we need to do on the disclosures, right? So that we've started the investigation, we've commenced the investigation, and then another disclosure to say that, the investigation has completed. So that's another.
Yeah, regulator has put the entire framework. If you get into the IC mode, you have to do the entire reporting. Exactly. So that those guardrails are in place. It need to be implemented. It need to be followed and adhered. And we as a GCs, as guardian of the organization, as a lawyers, external lawyers who are advising the organization, need to make the organization aware of. This is the next return filing to be done. If any such incidences have taken place, take it from the appropriate authority in the organization. Reach out to not only the directors, reach out to those in charge. The HR head need to be reached out for certain action, and that same thing can be again, the same thing can be again confirmed or accepted by the directors. So this is some kind of practices we as a GC need to follow, especially when it comes to external counsel in law firms. They need also keep their clients made aware of what are the guardrails which are required. And when you talk about regulators, it's N in India.
So reputation is one important thing which goes with the compliance, right? So
absolutely.
Compliance is a key thing for a company. You need to, and it's ongoing. And then there are multiple compliances which follow a single compliance.
I just want to keep one point maybe to the forum at large. Many of you, since you all have been in this fraternity of legal fraternity and have been counsels, many of you would have faced challenges where for the same matter, for the same type of work that you do, you may have various reporting for various regulatory authorities. Like I can tell you an example where I was doing an investigation which was regulatory driven. There were submissions to SEBI, submissions to income tax, submissions to GST, submissions to ED, submissions to others. And all had their own reasons of doing it, but I'm sure as a counsel, you would have also come across multiple such regulatory and law enforcement bodies where you would need to keep them updated about what's happening. In fact, there are regulations which says registered companies need to update SEBI on time-to-time basis. So I think, I have myself seen an absolute uptick in terms of how this has to be I would say how this has to be reported. There are multiple regulatory and law enforcement agencies where this has to be, they have to be updated about. Maybe if someone can just show some example, maybe Nitin, you can give an example.
No, absolutely right. There was a situation which I recently faced, and maybe that's not directly related topic, but let's talk about it. Every agency was reaching out to us, every agency in this country, for certain merchant who had done the transaction. And we were like, everyone, GST, investigation, income tax, ED, SFIO. So, and it was like same repeated, same point, answering to everyone. So probably the point is like, what we need to understand, everyone has a role to play. We don't disagree with that. But there has to be a central mechanism which need to be a custodian of all of this data, what we are giving them. And it becomes a big pain with the in-house compliance team who has to address all of this every notices, every issue need to be reported. When you get into this investigation mode, maybe you take it approach like GST department is only trying to look after the tax evasion part. The other department is going to look after the other part. Everyone has a role to play, but it becomes a lot of compliance burden, and ultimately it leads a cost factor which comes into the place. So when you talk about regulatory guardrails, SFI has a different role to play. The EDs have a different role to play. CBI has a different role to play. So all of these agencies should have some common point of interacting with each other, and I think Department Income Tax has started doing that with GST. What we are seeing now, they are getting the GST data, which is there. So that will control a lot of these issues and challenges of handling multiple law enforcement agencies in issue.
Absolutely, excellent. I think that works well. Interestingly, we are just not bound by the India laws. Being in India, and I can talk about your company, you know, you all are NYSE listed. They have extraterritorial laws which goes outside the jurisdiction of their country. Like I could say a US FCPA or a UK Bribery Act, where the laws are made in some other country, but are applicable for India. And it needs reporting. If something has been identified, like I worked on investigation which needed a reporting, being in India, needed a reporting in the US. So, you know, it's when we see ourselves, we don't see ourselves only with the lens of one country. It's one where we see organizations now who have been multinationals and who have their reporting obligations across the globe, is where I see that there have been a lot of other regulatory requirements globally which come into play. What has your experience been?
That's rightly said. So you just do not look into the eyes of one country, right? So especially when we are a multinational company, you need to look into, you know, various applicable laws, local laws of a particular, you know, country from where you're operating. At the same time, the other laws like the US FCPA and the UK Anti-Bribery Act. Having said that, now what is corruption to a particular country may not be corruption to another country. How do you define corruption? That's one thing. Secondly, on the compliance, while is it that, you know, as a company you can have a set of standards and policies in place to make sure you comply with all of these things, and you have a, you know, a compliance framework in place to make sure wherever your, you know, companies operate, out of whichever countries, that you make sure that, you know, the compliance have been met. But the challenging aspect to it is with your partners, with your third parties, with whom you contract with whom you engage with. How do you make sure that these third parties are also compliant with all of these things? That's one of the challenging part. Another challenge is on, as I said, on the local compliances, right? So it all depends upon the local variances in terms of addressing compliance with respect to corruption as such. So again, I would like to put that to both of you, right? In your experience, if these are the challenges which we see in a multinational company in terms of compliance or a regulatory framework, especially with respect to anti-money laundering laws, what would be your, you know, advice on how to overcome this?
No, when it comes to extra jurisdiction matters and the compliance of the other country need to adopt it, GDPR is a classic example. DPD has come up here, but in fact all of us were following GDPR. Indirectly it was implementing us, because if you have a foreign jurisdiction, any client who is in the foreign or individual who is doing transaction with the banking enterprise, foreign, the GDPR need to be adhered to. Especially the same goes with anti-bribery. When these entity you get engaged with this outsourced entity, they have those clauses in the agreement. Either you be very robust enough, take out those clauses, put it to the team members that this need to be adopted, send it to the relevant team that this is which is being agreed upon. Lot many times people are working in silos. The legal department has agreed on certain provisions. The department, the ops team, especially when it comes to something related to anti-bribery, which is whose function, there is a particular officer appointed for that. He is not aware in this particular contract this has been agreed. So it becomes very important within the organization also to make the people aware for other extrajudicial regulators what has been agreed in the contract, how those laws are creating an impact on us, and again making people aware is also critical. People bring with certain set of experiences from different industry. They come, listen to them in their experiences, make them aware that what is it going to impact. When you talk about NSE listed, then their listing regulations are different than what the listing regulations we need to follow, and we need to be adhere to both the regulation. It becomes very difficult at that point.
I give this mantra to my clients: what you can't do, you cannot get it done by anyone else. It's very clear from terms of ethics. What you can do can be done by anyone else, but what you can't do, if the ethos of an organization is very clear, that what you can't do in terms of anything, in terms of bribery, corruption, in terms of activities which may come under a PMLA, I think it's very clear that it cannot be done by others. Now, how do we pass it on to others? It's very important. Again, substance over form. Do we only keep a training, or we really actually make them ensure that they understand it better? Do we only put the clause in the agreement, or we actually have a round-up session with them to explain what does that mean? Do we only do a specific audit of doing a visit, site visit there, or we actually sit with them and understand their issues and try to find out solutions? So as an organization, I really suggest my client that if such things come your way, there are third parties or vendors which may be privy to such issues. Let it be India laws or let it be extra jurisdiction laws. I think the ethos of the organization can define how better you can do. And if the ethos are very clear with a zero tolerance, it applies to everyone.
I would like to add on to this, going back to our topic on investigative due diligence, right? And then about extra, if I have to link them, especially when you're into mergers and acquisitions, where you're acquiring an entity. Let's say you're acquiring a regulated entity, okay? A regulated entity offers services in a regulated space to multiple clients across the globe. So one, you have the industry relevant compliance which needs to look into. Another, you have to look into the local laws. So there are two whole big aspects which we need to look into from a regulatory framework. And if you are required to, acquire this particular target. So if I may say, a regulated industry like a pharma company which we are acquiring, or an oil and gas industry which we are acquiring, or a nuclear company which you are acquiring, right? These are all big things. So there's many things apart from a mere due diligence which we do, right?
Totally.
Not just looking into the documents as regards filings, but then whether one, you're capable of complying with this, whether you can take up this because you're going to be in that regulated space, one. Secondly, have this entity complied with all of this being in that regulated space? You need to investigate that. For that, you need to understand that industry very well before you get into the
That's right. So a lot of us are M&A experts here. I personally feel the core of M&A lies in due diligence, nothing else. Nothing else. The core of M&A is in due diligence, and due diligence should be so robust, so strong enough in the entire M&A, 90% of 80% of the time should be spent over due diligence and their findings. And if that is done in the right manner, I'm sure no M&A deal would reach to a conclusion which is hanging around here and there. Diligence findings are there that need to be clarified, that need to be open and discussed. And it's a human nature. Organization hides stuffs when they're getting sold, when there's M&A happening, there's certain value which they want to drive, and the other side wants to search something in there so that the value can be negotiated better. But this is the part of the process, and that need to be followed and adhered to. If someone is doing a M&A activity on a name or with certain understanding which is based on financials, not getting into the investigative mode, I think the deal maker should know better that those deals have not seen the light, or they have actually failed, or it leads to litigation in the court. So it's a very important aspect. 80% of your time in due diligence from all the legal angles, all compliances, regulated aspect was very important point, which say if you tend to acquire a regulated company, okay, everyone knows they need a yes from the regulator, but after the yes, you will be part of that compliance. You need to adhere to all of that. And this is a very important point. IRDA, like people want to acquire insurance company. The very fundamental factor, once you acquire insurance company, you give almost a blank undertaking to IRDA that promoter's liability will be unlimited. The promoter need to be made aware of that. Lot many times we have seen the promoter is like, no, let's get into insurance business, and this company is available in the market, and it's a very cheap. They have suffered some losses, we'll manage it. Whether your promoter know that you have to also give a similar undertaking to IRDA, where your liability will be unlimited. Something we as a GCs need to bring out. And all of this aspect comes out very clearly when you get into investigation, when you are aware of your deal expertise, and especially regulated industries deal makes a lot of difference when who is the acquirer and target company.
Yeah, another example is like, do all mergers and acquisitions survive, or do we achieve? We've seen the latest instance, what has happened with Sony and Z, right? I'm sure they would have done enough due diligence, enough investigations, but what happened during the course of the merger agreement kind of changed, what they were supposed to achieve, right? So there were certain closing conditions under the agreement which were kind of unresolved, including the disagreement in involvement of the CEO in the regulatory affairs. So all these things are also essential. So how much ever due diligence and investigation we do, whether this go through is also dependent upon certain factors as to what happens during the course of this acquisition and the course of merger.
Absolutely. I very much agree with you. Can someone pass on the mic to her?
We can hear you. Yeah.
So we are talking about due diligence. Do you think that there should be proper rules and regulations regarding due diligence? Because this might involve the aspect of money laundering.
Very important point. Very absolutely important. There is no proper set of regulation in what manner diligence need to be done, what need to be checked. People are just some people have gained expertise, but they are just following a traditional practice of learning certain way of certain things and trying to adopt that. And obviously, basic checks, I'm sure everyone is aware of. But there has to be a framework of doing that diligence. When it comes to regulated entity, there is a framework. When you go out slightly out from the regulated entity, I don't think there is a framework. And it's a very important point wherein the entire process, practice need to be adopted. Different bodies are there. When it comes to accounting, you have ICAI. When it comes to company secretarial work, you have ICSI. But when it comes to legal diligence, I am not aware if anyone can help me out.
What should be done in this regard? Like how India should proceed in this matter?
So I think before, I would like to answer your first question first. Should there be a uniformity in the way or a specific set in way a due diligence can be done? I have a little different opinion. Let me give that way to you. See, I have seen those transactions where the value is already decided. It is very clear that the transaction will happen through. And everything which is a problem gets entered into an SHA saying that if it's my past liability, I'll take it up. And I have also seen those which are extremely compliant driven, who go through all of these things, and if they don't go well, even after 1 year of negotiation, like you can take an example of Sony and Z, after 1 year of negotiations and discussions and approval and everything, still the deal may not fall through. So there are extreme, I would say, areas. What in this can be done from a uniformity standpoint is the various legal aspects and the various regulatory requirements, which could be, I would say, quite astoned in terms of these are to be done. But other than that, it is quite relative on how the transaction, or I would say, how would someone take up that transaction.
Probably her question is more, is there any body, what I understood.
You're talking
to my
about
knowledge, I don't know, I'm not aware of if there is any body.
We don't have a regulatory body.
Yeah.
See, having said that, all the companies who acquire, like the buy side, who acquire the target companies are very, very cautious because there's certain amount of risk which you are assuming, right? There's financial risks, there's legal risks which you're assuming while you're acquiring an entity. So it's not, so when it comes to due diligence, you kind of do all possible due diligence, like your fraud detection, misappropriation of funds. So all this has been done, but you need to be even more cautious that during the course of the agreement also that things have been
Yes,
met.
that is my concern. For example, initially you performed due diligence, right? There was nothing that came out in checks.
Yeah.
But during the process,
Exactly
if
what
there
I
is an
said.
involvement of money laundering, then how are you going to regulate it? There should be enhanced due diligence in that case.
So how are you going to regulate it? It is up to you whether to continue. That's what Sony rightly did, right? They terminated the merger agreement, which means they do not want to go ahead with the acquisition, right? So it's good that they found it during the course. Now what happens after the merger is being
Yeah,
done?
that is
That's a
basically one
different-
particular
yeah.
case, but,
so you
in
still
ge-
again can sue them.
Right.
You have the
No, so
legal course of
NCLT, if it is an
action.
NCLT approved merger,
NCLT, yeah.
There is a body,
the NCLT approved
NCLT is
merger,
a
then
body.
you can, especially to that part, can be handled in NCLT because when the merger process is ongoing and when the matter is reached to the court, and then both the parties need to give similar undertaking. Any point which has been not addressed rightly in the SHA or which goes the misrepresentation of reps and warranties can be taken up into the NCLT matter. It happened with me when I was doing the DHFL transaction. There were certain findings which were different on the day when we were about to reach to a conclusion. We raised that point that these numbers are slightly different from what was being expected. There's a stamp duty aspect which came out in the entire process. Though you have those capping of M&A stamp duty of 50 CR in India, but then there is when you are acquiring a company which is backed by mortgage lending. So this transaction should also, the NCLT gave auditors that no stamp duty impact today, and the court had the power to do that. So, and in fact, after getting the NCLT order, we had to go for an amendment because there's an interpretation issue. So if we talk about when it comes to M&A, hardcore, and it goes into court-approved process, there is a procedure. But the point I agree with you is what? Is there a body to, or do we have enough write-up on in what mechanism that diligence process itself should run?
We don't see the answers there.
Yeah, thank you so much.
Yeah. I just give another different twist to this investigations. We talk about regulatory bodies, but not necessarily only regulatory bodies. Even when you conduct an investigation, there are other bodies who would want to know because our investigation will define their judgment, like a statutory auditor. A statutory auditor, for them to know about the internal controls in place or to know about the true and fair of the statement and how the management has reacted or responded to a specific query is also there. So, we would say regulatory guardrails may not be there directly, but through the Companies Act and through the requirements of what has been mentioned for our statutory auditors, they also play a very important role when investigation has been conducted.
So you mean to say then there should be a qualified report by the auditors, a qualified report by the auditor. No promoter will agree to get a qualified report. They will push the auditor to the last level to not get a qualification in the report.
Yeah, I think it's about the awareness. It's about the awareness about this matter because that's they are bound to do. Whether the company has taken up the right steps, and it could be a matter which may not necessarily fall under into for a qualification, but may fall up into a specific requirement which has been taken care of by the company.
To this point, India is distinct. Like we have auditors coming to us by providing us notice. So we know when the auditors are coming to audit us so that we are well prepared, and we know what is being audited. Now what happens in foreign countries is something called as dawn raids, right? So the auditors come and visit the company without even giving you a notice. That's when the investigation happens, right? The regulator comes and then, there's a list of non-compliance, and then the corporate actually starts looking into the, non-compliances, and then there's a whole lot of investigation as to why this non-compliance.
No, interesting. If it is flowing from a regulation, accepted. Otherwise, in contract, one of the point which is mooted the most, other than those indemnity, limitation, or liability, is the inspection and right to audit. Every other side, the counterparty will object on this particular point related to right to audit and investigation. So if there is no regulatory backing to the investigation we're talking about, contractually they will ask you only one point. You will give us a notice, not even 10 or 48 hours, 7 days notice, 10 days notice, during business hour, all of that. If you look at contractually, the auditor is
You need
supposed
to correct the irregularities, right?
Exactly, that's what the point. So there need to be regulations around that area also.
Absolutely. Excellent. Yeah, so I think yes, one more came to us. One was regulatory bodies, and now we came about from an audit standpoint. Now let me add something to it. Investigations that I used to perform, or me and my colleagues, or my people in the fraternity that used to perform maybe 10 years ago, and when they do it now, I see a lot of difference. One of the differences that I see is because of the applicability, or about coverage in the DPDP laws. Because when earlier the investigations were performed, there were, because of lack of, I would say, knowledge about it, and awareness about it, investigations at times resulted in, I would say, identifying or using some data which they should have not used from a company's standpoint. But now with the laws coming in, this is going to be more regulated, and this is going to be helping us to take a right direction, which will allow us to do it in only one manner. What is your thought on that, Sushma? And maybe then you can add, because you already had a session of earlier before that, so maybe
I think
even you can add.
I think that was the point which missed in the data privacy session, which was there. Previous session, which was there. So it's not only people showing resistant when you are doing investigation. This is a challenge because it has to be done by professionals. And the professional, when I say, then he need to be bound by the professional indemnity or professional liability, which is the obligation towards that. So it becomes very difficult in situation when you are reaching out to a client in the investigation industry, and I on the other side of it, they want certain detail. I am not happy to say that detail. And there are regulations. The data privacy regulation is also one of the regulator. So those aspects, those provisions, those guardrails need to be built in. I think all of us use those virtual VDR, virtual data room, when you get into M&A transaction, wherein the data is put on the VDR and only certain people have access, and the entire VDR is monitored, every log is maintained. So there are tools, there are technology which need to come up and help us to do the investigation, and I'm sure AI is also going to play a part there.
Classic example of how data privacy can be misused in an investigation is, like an investigation is happening, and the person who is in the part, who's part of the investigation says that I refuse things to be recorded, right? The outcome of the investigation is a different thing altogether, right? When things have not been recorded, each party can again go ahead and allege that this was not told by me or this was told by us, right? So there's again a dispute going into it. So misuse of laws or misuse of regulations, how much ever guardrails you have in place, also needs to be taken into consideration.
I think we need to pivot it to a last, and I think it's time for us to conclude. We need to pivot it to the righteous way how you can do it. In my experience, I'll just conclude it by saying that yes, there are regulatory guardrails. These regulatory guardrails are robust. It's just that they need to be unified, so that we don't report to a lot of agencies, as you mentioned, again and again. But these guardrails help to give a equal opportunity for both people who are doing the investigation and also for people who have been subject to it. And it's absolutely no harm in giving that opportunity to others as well. And what can be done is let the investigation be done the way they are done, and that done by professionals. But on the other hand, we have legal experts who would help us support and assist in completing the investigation and doing a right disclosures to multiple authorities. That's it. Thank you very much, and happy to have some questions if there are any, or we would be happy to answer on the mic to her.